This has been a long legal fight. A downstate judge in a ruling today siding with plaintiffs who argued that the weapons banned by the law are used for self-defense. Illinois Attorney General quickly responding to that ruling with an appeal. Illinois' assault weapons ban deemed unconstitutional by a downstate judge Friday on the grounds that the Protect Illinois Communities Act violates the 2nd and 14th Amendments. It's been a courtroom battle since the legislation was signed into law by Governor J.B. Pritzker in January of last year in the wake of the Highland Park Parade shooting in 2022. But in a 168-page opinion by Judge Stephen McGlenn, the judge states, quote, "While the court is sympathetic to those who have lost loved ones to gun violence, such tragedies are not an excuse to restrict the rights guaranteed to the Illinois public by the Second Amendment to the United States Constitution." Dan Eldridge is one of the plaintiffs.
You do not penalize the law-abiding who are possessing something lawfully for lawful purposes just because of the deranged acts of depraved individuals.
In a statement after the ruling, Governor Pritzker said in part, quote, "Despite those who value weapons of war more than public safety, this law was enacted to and has protected Illinoisans from the constant fear of being gunned down." A swift appeal by the Illinois Attorney General setting the stage for this legal battle to wage on.
It really gets final when the Supreme Court either takes the case, considers it, and rules on one side or the other, or where the Supreme Court refuses to take the case at all, in which case the ruling of the Court of Appeals will stand.
And while that appeal plays out in court, judges will hear the case challenging Cook County's assault weapons ban on Tuesday.